And welcome to the first episode of the Habeas Corpus Project's broadcast, where we will be bringing you bi-weekly news and case analysis on all matters immigration detention. My name is Dina Mansour, and I'm a student volunteer at the Habeas Corpus Project.
Hello everyone, my name is Anna Ashford, and I am also a student volunteer at the Habeas Corpus Project.
The Habeas Corpus Project is a charity that provides free legal representation to immigration detainees. Please find the link below to our donations to help support the cause. I will now be asking Anna some questions about the current updates on immigration detention. So Anna, what's going on in immigration detention news?
Well, Dina, a recent report into immigration detention from earlier this year, commissioned by the Home Secretary, has described the practices and process of immigration detention as an urgent need of reform. The report was written by former prison ombudsman Stephen Shaw and called for ministers to reduce the number of people who are detained, which is currently at 30,000 a year, boldly and without delay. The report was commissioned as a response to sustained criticism of detention practices and widespread allegations of death, self-harm and sexual abuse.
And what exactly does Shaw's report highlight?
Shaw's report strongly criticises the high rates at which detention is utilised. His main concern is that there is too much detention and that it is not a particularly effective means of ensuring those with no right to remain do in fact leave the UK. Furthermore, he stresses the fact that most of those in detention do not present a serious risk to the public, a justification that is often used by the Home Office in their decisions to keep people in detention. Shaw also importantly notes that many of those detained have strong domestic links to the UK, which he highlights to demonstrate the fact that they represent a very low risk of non-compliance. We find it quite important that Shaw makes this point because we witness many cases of the Home Office presenting detainees as being at risk of non-compliance because of their lack of strong ties to the UK, when in reality, many of those detained were raised in the UK, knowing it is their only home.
And how does Shaw address issues of mental health and well-being with detention centres in his report?
Well, Dina, that is a very important question. In Shaw's damning report, he notes that treatment and care of people with serious mental illnesses does not equate to good psychiatric practice. Detention can trigger re-traumatization of those with PTSD, post-traumatic stress disorder. A stark consequences of this deficiency occurred 1 month after the publication of Shaw's report, when a man was found dead in Colnbrook Immigration Removal Centre. Amir Simran Tov is thought to have been in his 30s and, according to a fellow detainee, on suicide watch. The cause of death has not yet been established, and the police have launched an inquiry into its death.
And would you say that the report suffers from any essential drawbacks?
Yes, I would say that the report fails at a crucial aspect to directly address the recommendation by an earlier cross-party parliamentary review to impose a time limit on detention, a measure that would bring the UK in line with all other countries in Europe.
Has the government yet responded to Shaw's report?
The government has responded, their response being to officially accept the broad thrust of the Shaw recommendations and set out a new approach which seeks to achieve a reduction in the length of detention and the number of those detained.
Well, Anna, thank you for your contributions on the Shaw report. We'd now like to move on to another pressing concern. How have the pitfalls of the immigration detention affected women?
Well, in the past few months, there have been more concerning reports on the conditions of female detainees in Yardswood Immigration Removal Centre. In an article in The Independent, one detainee who has previously served a prison sentence describes her time in Yardswood as worse and details instances of violence, abuse and a woefully inadequate provision of healthcare services.
And how have the dynamics of immigration detention played out in the courtroom?
Well, we think it is very important for the public to understand what the main purpose of detention is, namely to effect removal from the UK. High Court Judge Mr. Justice Garnham reaffirmed this fact in his judicial review decision on the case of AB. After more than 2 years in immigration detention, Justice Garnham ordered the release of AB. AB came to the UK as a teenager from Zimbabwe. He had committed a series of offences, given a 30-month sentence and subsequently transferred to immigration detention in October 2013. In the judicial review hearing, Justice Garnham accepted that AB was likely to abscond and reoffend, but reaffirmed that AB's continued detention was unjustified because there was no prospect of deporting him. The ruling emphasises that the correct and lawful use of detention is solely to effect removal from the UK, a fact that is often, regrettably, overlooked, and this highlights the importance of judicial oversight when an individual's liberty is at stake.
Well, Ed, I'd like to thank you for providing us with this update, and we will now be moving on to the segment involving case analysis. Thank you.
Hello, I am Osman Noor, the director of the Habeas Corpus project.
My name is Peter Walker. I'm a student volunteer at the Habeas Corpus project.
In this section of the broadcast, we're going to be analysing two cases relating to immigration detention. They relate to the detention of those suffering from mental illness. The first case is the case of SR, and the second is the case of MD. I'm going to talk about the case of SR. So, Peter, what would you like to know about this case?
So could you give us a brief outline of the facts of this case?
This case involved a Ghanaian gentleman who came to the UK in 2005. He came on a 6-month visit visa, but ended up overstaying that visa. There's no record of him ever having worked or claimed any benefits or committing any criminal offences whilst in the UK. He was being looked after by a church who provided him with food and accommodation. Now, in the end of 2011, he was caught behaving strangely on the streets. It was later realised that he was suffering from paranoid schizophrenia, a severe form of it, and psychosis. The police came to investigate and detained him. They realised he was an illegal immigrant. They informed the immigration department, who then detained him for a further 110 days. And this was despite 2 expert psychiatrists confirming at the beginning of his detention that he was suffering from paranoid schizophrenia and psychosis to such an extent that he wouldn't even be able to understand the case against him. He wouldn't be able to understand questions asked of him. His cognitive impairment was that bad. Nonetheless, they continued to detain him. They did not conduct any proper assessment of him, and went and processed an asylum claim for him without a solicitor present, asking him the questions that the expert said he wouldn't be able to understand, and then ended up making an order that he should be immediately removed from the UK. That decision did have a right of appeal, and in March, a judge, having seen him for the first time, ordered that he should be released. Those are the facts of the case.
So then what was the arguments that the claimant brought in this case?
So after he was released, his solicitors made a claim that for those 110 days, his detention was unlawful. They relied primarily on Section 55 of the Enforcement Instructions and Guidance. This is the Home Office's own document of how to treat people in detention. Section 55 says that those suffering from serious mental illness should effectively not be detained unless there are exceptional, very exceptional circumstances. Also, the Detention Centre Rules of 2001, Rule 34 of those rules say that within 24 hours of someone entering detention, a medical examiner should assess whether or not they are suffering from serious physical or mental illness. Rule 35 of those rules say if later on it becomes apparent that someone is the victim of torture, suffering so badly from physical or mental illness that their health cannot be properly maintained in detention, medical examiner needs to look into that, produce a report, and a decision should be made whether or not detention should continue. The arguments were that Rule 35 report never took place, a Rule 34 report never took place, and overall the Secretary of State failed to comply with Section 55. They said that the requisite assessments were not conducted, the proper necessary antipsychotic medicine was not provided, no counselling was given to the detainee, no monitoring of the mental health was provided, and there was a failure to investigate the causes of the cognitive impairment that he was suffering from, and a failure to really reflect on the fact that he would not be able to understand the questions or the answers relating to his asylum claim. So those are the arguments made by the claimant. The Secretary of State's response to all of this was simply that his condition was not that bad. All of the other arguments that they made spawned from that basic position that his condition simply wasn't that bad, and that's why they didn't do any of those other things.
So how did the judge then end up ruling on this case?
The judge in this case was scathing of the Home Office. A very long judgment, 150 pages or so judgment. The judge goes into very fine detail, looking at all the medical notes, every tiny little procedure that took place and what didn't take place, and concludes that the treatment and care provided by the Secretary of State whilst he was in detention was inadequate in many varied and extensive ways. It says there were extensive failures to apply the various applicable policies, some of which can only be described as willful willfully or grossly negligent. That's a pretty serious thing to say about the government. Okay. He also says, more generally, that the Secretary of State has given little understanding to the caseworkers, little guidance to those caseworkers on mental illness as a whole. He says there is no recognition of the need to treat them with dignity or respect, or to provide them with the minimum standards of care or the minimum standards of assessment that they are entitled to. He says these failings are exacerbated by any clear guidance provided by the Secretary of State to the caseworkers. So it's a very damning case, and this gentleman was actually awarded damages for that time he spent in detention. So you're going to be talking about the case of MD. Tell us a little bit about the facts of that case, please.
So this case involves a 24-year-old Ghanaian woman arrived in the UK in 2011 to join her husband of 7 years who was living here legally under refugee status. After being interviewed, she was denied entry and then subsequently detained in Yarl's Wood for over 17 months. As a result of her detention, she began to self-harm a mere 4 months into her detention and developed various forms of severe mental illness, including major depression, anxiety, and eventually PTSD, which was diagnosed by 3 separate psychiatrists whilst she was in detention. So those are the brief facts of the case.
And what arguments were made in the case?
So essentially, the claimant argued that her detention was unlawful for 3 main grounds. The first was that after 6 months in detention, it became clear that there was no realistic prospect of the Home Office being able to effect her removal, as the power of detention only exists for the purpose of deportation. Once it becomes clear that this won't be effected within a reasonable time, then her detention will be arbitrary and unlawful. Her second ground was that her severe mental illness made her unfit for detention according to the Home Office policy that you mentioned, Section 55. And the third was that her detention breached her human rights under Article 3 and Article 5 of the European Convention of Human Rights, which is right not to be subjected to inhuman or degrading treatment or punishment, and the right to liberty and security, respectively.
And what was the Secretary of State's response to those allegations?
So essentially, they argued first that throughout the whole period of detention, there was indeed a reasonable prospect of overcoming the administrative barriers to her removal and effecting her deportation within a reasonable time. And secondly, similar to in your case, they essentially said that her mental illness was not that bad and it didn't reach the threshold for their policy to be applied, and that no exceptional circumstances applied. Thirdly, that her Article 3 rights were not breached, as detention of the mentally ill does not itself constitute inhuman or degrading treatment. And that as for Article 5, it would follow that there was no breach of that right if her detention was lawful in general.
And how is this case concluded?
So the High Court judge was similarly scathing. He ruled that from a period of 6 months in, it was, given all the circumstances taken into account, very clear that the Home Office had no prospect of effecting her removal within a reasonable period of time. Secondly, that the Home Office had indeed failed seriously in applying their own policy regarding detention of the mentally ill, and that no exceptional circumstances did apply to justify her continued detention once it became clear that she was suffering from major depression, PTSD, and anxiety. And thirdly, that their inadequate treatment and misdiagnosis of her mental illness itself constituted inhuman and degrading treatment and was a breach of her Article 3 rights. As a result, she was entitled to unnamed damages, likely of a very significant amount.
So those are 2 cases in which the Secretary of State was deemed to have held people in detention unlawfully, people suffering from severe mental illness. In the time that we've been practicing, since 2014, we also come across instances where people are suffering from mental illness, and the Secretary of State seems to do very little about improving their condition. The guidance is very clear. Such people should not really be detained, save in exceptional circumstances. In these cases, clearly the Home Office continue to detain them regardless. The Habeas Corpus project will continue to work to expose such instances of unlawful detention and provide the right remedy where it is needed. Thank you for listening to this podcast.